think very hard before they go into court. We have the American rule, or what I like to call the lawyer's full employment rule, and it works like this. Let's see, let me pick someone out of the audience. What's your name?
Troy.
Troy, I've never met Troy in my life. Do you know how much it would cost me to sue Troy?
Nothing.
About $500 to $600 in terms of court costs, filing fees, and service of process fees. I can sue him for anything I want, realistically, except divorce probably, but I can sue him for almost anything.
In California.
Under Obama.
But here's the point. Now, as an attorney, I would have to put in my time and effort, and yes, I might have to get expert witnesses and pay those other costs. But the actual bare cost is about $500 or $600. And here's the thing. If I sue Troy, even no matter how ludicrous, his lawyer might say, they're ready to settle for $10,000. And Troy's going to go, screw that, I'm going to take him to court. And the lawyer's going to say, no, you're not. You're going to pay him $10,000 to get him out of here because you don't know what's going to happen in court, and it's a year of your time, and oh, by the way, my legal fees will be about $25,000. So Troy gets really angry at me, writes a check, and I try not to gloat too much. That's the effect of not having a loser pays rule. It stimulates litigation, it makes it easy. It's why a medical malpractice attorney or personal injury attorney will file 100 cases knowing that 60 or 70% of them are dead losers, because they know that some will lose, but they'll get a lot of these token settlements that help pay the bills. Then they'll get a couple of big ones that'll win. And then they'll find one of those whales that allows them to buy the Ferrari or make their name. That's the whole point. The costs of a litigation are outrageous. And more to the point, if I want to discuss things like tobacco or civil rights or disability law, when I know I have a weak case, I want to be able to file 10 or 15 of those cases until one of them sticks, over and over and over. There were dozens and dozens of cases involving tobacco litigation over the years. It wasn't until Fred Levin sat down with Lawson Childs and changed the law to facilitate a victory that they won. They just kept going it over and over and over again. We see this in the fast food cases. They keep talking about fast food being bad. They want to sue the fast food companies, and the cases never go anywhere. They will eventually win just by the strength of numbers. I mean, I know fast food is bad for me. But you know what? If I play my cards right, I might be able to convince a judge that it's their fault. Maybe I catch the judge when he got food poisoning at Wendy's Burgers or something. This is how it happens. Contingency fees. Basically, a lawyer will tell you these are the keys, working man's keys to the courtroom, and there is some truth to that. It allows you to sue without putting any money down. But it also allows you to sue without consequence, because if you lose, you're not going to be on the hook for anything. And if you win, you're only paid by what's recovered. So it makes you, the average citizen, easy to go to court. A lot of people come to me and ask me about suing someone, usually in a property or a business dispute. And very often I tell them not to do it because of the costs involved, or because it's not a good case, or they don't have merit, or there's mitigating circumstances. I even have people who just come in sometimes and say, I'm curious about what my rights are, or should I pursue something, but they're not really interested in suing anyone. They just need to check. And I will usually give them a fair assessment. And in fact, my job is to keep businesses out of a courtroom. That's what I do for a living, because litigation kills business. But there are lawyers out there, because they have a stake in the outcome of the case, who will say, you need to sue, you've been screwed over. We're going to take him to the cleaners, and it's going to cost you nothing. And many of these folks are burnt out by the end of the case, but it doesn't matter. The case has already started, and it wins. Contingency fees give an attorney an incentive to cheat, an incentive to file, an incentive to be aggressive, an incentive to pursue big damages, an incentive to go for the brass ring. It gives clients the same incentive, because they lose nothing by trying, but they could lose everything by not being aggressive. And very often, if you're aggressive, that means you will lie, cheat, and steal, and do whatever it takes to win. That's the important thing about contingency. It makes cases easy. Public interest, even worse. There are a number of laws out there that say that you can bring a suit on behalf of the U.S. government to enforce a law, and if you recover funds or damages, you get to keep a huge chunk of it. Bounty hunting, for lack of a better word. Under the RCRA Act, Resource Conservation and Recovery Act, if you bring a lawsuit against a landowner who has contaminated property and you win, you get to keep about half of the damages. That's great. The government doesn't have to lift a finger and it gets damages. And a great social ill has been corrected because contaminated land will be cleaned up. But what you don't realize is that creates an incentive to sue. Some of the wealthiest lawyers are, quote, public interest lawyers working on behalf of the little guy. They drive really nice cars, they are very wealthy, and they file a lot of lawsuits.
Is that where the lawsuits that involve class actions?
That's different.
Okay.
And good subject, but not what I'm talking about tonight. So those are the three things. Those three things create two things. One, it makes it easy to sue, which makes us a lot of litigation, which is why we're the most litigious country. We have the most lawyers, and things cost a lot, and life is not as good because we're all worried about getting sued and liability risks. But more importantly, for what I'm talking about tonight, those are the three rules that make judicial activism happen. Those are the rules that allow people, liberals, social activists, to get their cases in front of liberal, social activist judges who want to engage in judicial activism. They get the cases in front of the judges who can make the decision, and that's how they legislate from the bench. That's why we have a judicial activist problem in this nation. And so remember that. It's not just the judges. Because remember, I'm running for judge. I can be good, I can be bad, I can be honest, I can be dishonest. I just have to get elected. And there are good judges and there are bad judges. And there are good liberal judges and bad liberal judges, good conservative judges, good bad conservative judges. That's part of the equation. But it's this ability to give judges the temptation to meddle around, to do what they think is best for everyone, to do the things that are on the side of angels. These cases are what give them the opportunity. It's like a murder. If you murder someone, you need motive and opportunity. For judicial activism, you need motive and opportunity. There's a lot of judges who have the motive, and all they need is the cases brought before them where they can meddle and have that opportunity. I'd like to conclude with a few thoughts as to what you can do to help. Because you as a group are far more effective than you can know. Right now across this country, Tea Parties and patriot groups are being labeled as extremist, racist, weird, eccentric, and it's because they've got nothing better in their arsenal. They have to marginalize you because you're effective and you're changing things. I know this because I'm in a race, and the minute I became a front runner in that race, I started getting attack ads. My personal favorite is the Lawson, our liberal bumper stickers, which even Democrats think is a real hoot, but that's another story. The point here is you can be effective. Here are some things you can do over time, both individually and collectively. First, we need to return to the negative option of judicial review. You can only void all or portion of a law or treaty if you believe it conflicts with the Constitution. When you are dealing with elected officials you might want to endorse, ask them to take that position, that they will be only appoint people who will strictly interpret the Constitution and no more. You also want to get involved in the various judicial nominating committees. There's one in Florida that has 4 non-lawyer members on it. Most states have that. There are advisory groups. There are bar groups that allow civilians on. You want people on there who will push for non-activist judges, who will strictly interpret the law, who only believe that judicial review means you can void all or a portion of a law. Second, find good people to serve as judges. I'm running in a race which is going to cost me over 6 figures of my personal savings. I have put my practice at risk, all for the privilege of taking a pay cut if I'm elected. It is very hard to find good judges. Also, I'm not a trial attorney, which means I have to fight an uphill battle to do that. I'm one of the few candidates that doesn't have that incentive. You need to find similar people who are willing to take on the privations of running for public office, county commission, judges, and whatnot, and undergo the torture that is a race. I've learned to enjoy the process, but I got to tell you, it is an uphill battle, And the reason we have bad politicians and bad judges is because nobody else is willing to step up to the plate. It is an